Hey everyone, it's Sameer, the tech visa lawyer. Today I want to talk about why doing an EB-1 is kind of like fighting in a battle. Why do I say that? Well, the EB-1A in particular has a 50% denial rate nationwide. That's approximate. So the government, they try to take their job very seriously to make sure that whoever they approve can be said to be at the very top of their field and has received a sustained amount of national or international acclaim. So like I said, they take their job very seriously, and sometimes they'll go to extreme ends to try to make that happen. And one of the things they tend to do is after you file a petition, they almost automatically issue RFEs, and they have these super long boilerplate templates that they kind of throw in. They either sometimes read or sometimes they don't read your entire petition, or they parse, your evidence and kind of pick out the things they don't like and harp on those. So they tend to do whatever they can to almost make you feel like discouraged about whether or not your EB-1 is going to get approved. So when we get an RFE, then we respond to it. It's almost like filing a second EB-1 petition. So that's super hard, it's a lot of work, it's a lot of time, can be really expensive, although our firm doesn't charge extra for RFEs. When we submit the RFE, like I said, 50% of cases, at least not our firms, but nationwide, they get denied, right? And so the denials often after an RFE, they almost don't even acknowledge, this is most often the case, they don't always acknowledge the evidence you submitted. They go back to their original rationale that they used in the RFE, and they use that to deny cases, almost kind of daring you to challenge them. Right? So one thing that we do, and we've kind of figured out this works pretty well, is to take denials like that and sue them in federal court, take it out of USCIS, out of the entire kind of chain of the executive branch, to the judicial branch, into federal court. And when you sue the government in federal court, they have 2 months to respond to your complaint. What we've seen, at least here in Northern California and some other jurisdictions, is that within those 2 months, they reach out to us through the US attorney and ask us if it's okay if they reopen the case, maybe issue like a face-saving RFE, and once they approve the case, will we withdraw the lawsuit? So you can kind of see that a lot of times the denials and the kind of the trouble they give you at the USCIS level doesn't really hold any water when it comes to actually going to court. So that's kind of like the typical lifeline of an EB-1 that isn't approved. It can be pretty bloody. It's a rough landscape, but relative to, at least for Indians, waiting for the EB-2 backlog, it's still much better. So do we discourage you from applying if you qualify? Absolutely not. Just kind of know what you're going to get yourself into. You're going to be in for a little bit of a battle. Any questions, feel free to email me, info@banyan.law. Thanks so much.